Welcome. And as you've just heard, this is now being recorded, this session. So welcome. We're going to be talking about your rights in the workplace. And yes, you can see I'm a lawyer at JobWatch, Community Legal Service. But this session is, of course, general information. It's not specific legal advice for any one person. If you do have questions of a general nature that would benefit everyone, please, 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 as Alexander said, use the chat function and all the GSA people will help me. I'm sure you'll just read out any questions that pop up that I might miss along the way. And of course, I also want to acknowledge the traditional custodians of land and waters across Australia, and I'm on the lands of the Wurundjeri people of the Kulin Nations. So everyone, these are the topics that I want to focus on in the next hour, or in fact, a little bit less than the next hour. Firstly, I believe that a lot of you, or probably most of you, are international students. So I really want you to know that we have a specific project for international students. It's called the iSeals, and I'm going to talk about that first up. But then the rest of the information is going to be for everybody, even if you're not on a student visa. Everyone needs to understand the difference between working as an employee or working as a contractor. So we'll look into those differences. Then if you are an employee, it's important that everyone understands the different rights that casuals have versus permanent employees. Then we'll talk about getting paid, which of course I'm sure is of huge interest to everyone. How can you check what the minimum pay should be for your specific job and what can you do if you're not getting the right pay? Superannuation as well. What are the rights that you have in relation to superannuation? Pay slips. What kind of information should be on a pay slip and what can you do if you're not a pay slip, which is what we often call a cash in hand job when you're not getting pay slips. And then those next couple of things are, of course, occupational health and safety issues that can sometimes happen in workplaces, unfortunately, workplace bullying and sexual harassment. How do you recognize when these things are happening either to you or around you, and what can you do? And then finally, I'll be ending with the information about how to contact us for help if you ever need us in the future. Of course, I should just preface all of this by saying I wish you all the very best in terms of your work experiences. There are plenty of employers that are trying to do the right thing and want to treat employees well because they know that, it's important to treat employees well in a competitive market. They don't want to lose you. However, obviously, I'm here because we believe that prevention is better than cure. It's much better for all workers to know what your work rights are before you start a new job, or at least as soon as possible, so that you can try to prevent things from escalating and becoming worse. Or if there is a problem, you know who you can go to for help. Okay, so let's begin. I said before that for those of you who are on an international student visa, there is special help available to you. JobWatch has lots of different projects on the go, and one of our projects is called the iSeals project. iSeals is an acronym for that very long title that is in red. So it's called the International Students Employment and Accommodation Legal Service. So it's not only work rights, as you can see, it's also any problems with your accommodation providers, whether it's private or public or university, whoever owns the accommodation where you live. If you have problems and you need some legal advice, you can also access this same service. Of course, you see in the middle bullet point that there are 3 community legal centres that are in partnership. So JobWatch, West Justice and Southeast Monash Legal Service. And we all go to the Study Melbourne Hub, which is in Hardware Lane in the city, to give legal advice to international students. So the Study Melbourne Hub is like the central place where international students go for any problems that international students are experiencing, you are welcome to go and speak to a caseworker at that student hub. And then if the problem relates to work or accommodation, then the caseworkers will make the referral to JobWatch or West Justice or Southeast Monash Legal Service. But even if you have an issue that you need to talk about with the caseworkers that is not employment or accommodation related, other problems that you might be facing, you are welcome to go and speak to those caseworkers. And they've got really good relationships with all the various organisations across Victoria that might be able to help you with your particular issue. So as you can see down in the yellow highlighted bit, the crucial thing to understand here is that by coming and getting legal advice, if you do have any problems that are work related, please be assured that it's all free and it's all confidential, the legal advice that you will have. So we're not there to go and tell your employer. We're not going to be telling anybody else, obviously, without your consent, okay? Because it's confidential and you don't pay a cent. It's a free service. So make the most of it. All right, now jumping into the next topic, which is what are the different rights that employees have compared with independent contractors? Now you can see firstly in the highlighted bit at the top of each column, I've put that an employee usually works with a tax file number. TFN stands for tax file number. An independent contractor instead works with an ABN, which a lot of you probably know stands for Australian Business Number. So that's already a big difference. However, I don't want you to think that just because you're using an ABN, it definitely makes you an independent contractor, because sometimes we know that sometimes businesses or companies might say to you, you need to have an ABN to work here. And so you get yourself an ABN and then you use that ABN. But really, you're not running your own business. You're not a true independent contractor. You really are working as an employee and you should be treated as an employee. But you're just using the ABN because that's what they told you to do. Okay? So have a look at the words in red under employee first. This is the essence of being an employee. An employee has their work controlled by the employer. And what I mean by that is every detail really is controlled. Where you work, when you work, how you work, and what you work. So all those W's and H's. Where, when, how, and what. It's all controlled by the employer. Versus, have a look under independent contractor, the words in red, they are the key. That's very different when you're an independent contractor, a true independent contractor. Because if you are truly, genuinely an independent contractor, it means that you are running your own business. So that's why that word independent is important. You are not controlled by the employer. You are independently running your own business. So you get to control what work you do and how you do it and when and where you do it. I hope everyone can see that big difference between these two types of worker. So going back to the column of employee, if you're an employee, you should have all your equipment or tools that you need for the job. They should be provided by the employer. And if you are an employee, you will be entitled to a minimum rate of pay for every hour that you work. Now, this is really important because this is where there's a huge difference, okay, between these two rights. Employees are protected by the law so that there is a minimum hourly rate for every hour that you work. If you are genuinely running your own business, on the other hand, the law assumes that you don't need the protection of the law because you're independent, you're running your own business, so you can negotiate. You can decide how much you charge for the job. And so you might say This job, you go and have it depends obviously on what kind of business you're running, but you think about the whole job that needs to be done and you give a quote for the whole job. It's not about being paid a certain rate per hour that you work. Okay, so that's a very big difference. And if you are genuinely running your own business, you bring any tools or equipment that you need for the job. So a really good way to think of this is if you need to call a tradie, let's say you need to call an electrician to come and fix some wiring in your home. When you call the electrician, you are not employing the electrician. Okay, you are asking someone who is running their own business to come and give you a quote about how much it will cost to fix the wiring in your home. They are running their own business. They have their own Australian business number. They will give you a quote. And then if you say, yes, go ahead and fix it, please, then at the end, when the job is done, they will issue an invoice. And on that invoice, it has, the details of how much you need to pay and by when. And then they take care of all their own tax. They take care of their own insurance. They bring, obviously, when they're doing the job, fixing your wiring, they bring all their own tools and equipment. That's a perfect example of someone who is running their own business as an independent contractor. Okay. Any questions on these differences between the rights? Take yourself off mute. Feel free to just jump in and ask if you've got a question. Otherwise, use the chat box. All right, I'm going to keep going. Now we're going to focus on if you are an employee, it's important to understand the difference between being a casual or a permanent employee. I'm not worried about the number of hours in a week that you work. Of course, a full-time week is usually 38 hours, 37 or 38, depending on the industry, and anything less than that is considered to be part-time hours. But full-time or part-time, that's not the thing that makes a difference to your rights. What really makes a difference to your rights is whether you are a casual employee or a permanent employee. And of course, you can be casual full-time or part-time, and you can be permanent full-time or part-time. Okay, so it's about understanding, am I a casual or am I a permanent employee? Now, you will be a casual employee if, when you made the agreement, there was no firm advance commitment. Those words in red, I know they sound legalistic, but they are the key words from the legislation. No firm advance commitment to continuing an indefinite work. On the other hand, if you are a permanent employee, which of course, especially if most of you are on a student visa, you would be permanent part-time employees. In this case, there was a firm advance commitment to ongoing work when you first made the agreement. Okay, they locked in with you, or both parties, the employer and the employee, made an agreement that, for example, every week going forward, you will work on a Monday, a Tuesday, and a Wednesday from 9 until 5, or from 9 until 2 p.m., let's say. And those 3 days a week, they are your minimum hours. That's the commitment. So you've locked in those hours. You can plan the rest of your life. You know then when you can have time for study or other things, okay? Because you've locked in those hours and it's on an ongoing basis. Instead, if you come back to the casual slide, there's no firm advance commitment to continuing an indefinite work. And therefore, what this means is that you have no guaranteed hours. Your hours can change every week. Some weeks you might work a lot of hours, some weeks you might not, because it's all about when the employer needs you. So you have to check your roster to see when are you working next. If there's no security about your hours, then you're a casual, okay? Now, like most things in life, there are pros and cons. advantages and disadvantages to both of these. I'm not saying that one is better than the other. They're just both different. So some of the disadvantages to being a casual employee include that you don't have the security of the hours because they can vary. You don't have paid leave. So if you have a look at permanent employees, they do have paid annual leave and paid personal leave. Personal leave is the umbrella term that includes both sick leave if you are sick and you can't go to work, and also carers leave if someone in your immediate family or your household is sick and they are relying on you to look after them that day, then you can take carers leave. But both sick leave and carers leave together, they are called personal leave. Now, if you are a permanent employee, these types of leave are paid. I mean, it's not indefinite, of course. There's a certain number of days. So just so that everyone knows, the amount of paid annual leave, which is your holiday pay, that a permanent employee is entitled to is 4 weeks per year. 4 weeks. So that means if you're a part-time employee and you usually work 2 days a week, it means your normal week is 2 days. So it's 2 days times 4 weeks. Okay, so it would be an equivalent of 8 paid days per year. So that's how that works. 4 weeks of annual leave and 2 weeks of paid personal leave. Again, if you're part-time and you're doing 2 days a week, it would be 2 days times 2 weeks. Okay, that's the equivalent of personal leave. Now, the personal leave you can take, and same with the annual leave, it doesn't have to be taken as a whole day at a time. It could just be as a number of hours or half a day at a time. Coming back to the casual, in the 1, 2, 3, the third bullet point, you can see that I've said there, you are not entitled, when you are a casual employee, you're not entitled to paid leave, but there is an exception, which is paid family and domestic violence leave. In case anybody is experiencing family and domestic violence, even if you are a casual, if you have to have some time off work to deal with the family and domestic violence, for example, you need time off to go to a doctor's appointment, a legal appointment, to change house or anything like that to deal with that, you can have paid time off work even if you are a casual. And the last point on this slide is that when you start a job as a casual employee, you should be given 2 information statements. One is called the Casual Employment Information Statement, and the second one is called a Fair Work Information Statement. Everyone should get the Fair Work Information Statement. Even if you are a permanent employee, everyone is entitled to that one. But then casuals also get that extra one specific to the casual rights. Okay, so I've just gone through a lot of the not so good things, right? Some of the bad things about being a casual compared to being a permanent. But the one really good thing about being a casual employee is that you get extra pay per hour. So this is the second bullet point on this slide. You do get a casual loading, which is usually 25% extra if you are a casual employee. So you can see, I'm not saying one is better than the other, they're just very different. Again, if you have any questions about these things, please either take yourself off mute or put them in the chat. Now I'm going to go on to the minimum wage issue, which I know is of interest to everybody. Let me start by saying that the strange thing with the minimum wage in Australia is that for most other things, we become adults when we are 18. But the adult wage is considered from 21 years of age or older. So if you're under, for anyone who's under 21 years of age, which probably no one in this session is under 21, but if you have siblings or friends who are younger than 21, keep in mind that there are slightly lower rates of pay when you are under 21 because they're called junior rates of pay. So once you've understood that, the next important thing to understand is that at the moment, the national minimum wage for adults is, and you can see those two amounts here, 24.10 per hour if you are a permanent employee and $30.13 per hour if you are a casual employee. However, please, please, please do not think, everyone, that they are the only important rates. And as long as you get those rates, then you're okay. Because it's very possible, in fact, I would say highly likely, that many of you will be entitled to a higher pay than these two amounts here. And that's why I've said you always need to check, are you covered by a modern award or an enterprise agreement or an employment contract that gives you a better entitlement? Any of these documents, modern awards, enterprise agreements, and employment contracts, they can be better, but they can never be worse than these amounts here. Now, I'm guessing that a lot of you don't know what a modern award is or an enterprise agreement is. So I'm very quickly going to explain. Both of them, they are booklets. They are booklets with all your minimum conditions at work. But the big difference is that a modern award applies to everyone that works in a particular industry or occupation. So, for example, the restaurant industry has a modern award. There's a hospitality award. There's a cleaning services award if you work as a cleaner. There's lots of industry-wide or occupation-wide modern awards. We have more than 100 of them that exist in Australia. And then an enterprise agreement. Enterprise is another word for business. So really it means a business agreement. It's instead of being applicable to the whole industry or the whole occupation, enterprise agreements apply specifically to your employer. Now, not all businesses have an enterprise agreement. So you need to check when you start your job, does your particular business have an enterprise agreement that is specific to your business? If it does, then that's the booklet that you need to look at, because that's the booklet that has the information relevant to your terms and conditions. If there is no enterprise agreement for your job or your workplace, then you are most probably going to be covered by a modern award that is for the whole industry or occupation. And with the last point that I made there about the employment contracts, please don't think that if you haven't signed an employment contract, then it's not valid or it's not legitimate, the agreement that you have with your employer, because you probably know by now that in Australia, it's perfectly fine to have a verbal contract. It doesn't have to be in writing. Of course, as a lawyer, I would always encourage you, it's much better to have things in writing, because then it helps you to point to what's in writing to say, this is what we agreed to. But even if it's not in writing, you still can enforce a contract. However, if the employer says to you, here, shake my hand, we have an agreement that I'm going to pay you $15 an hour, then of course you can see $15 an hour is less than the national minimum wage, isn't it? So that's not enforceable. It doesn't matter that you shook their hand and you said, okay, thanks very much. It's not enforceable, because you can't ever agree to something that is less than your minimum. And your minimum, we already know, your minimum has to be at least 24.10 or 30.13. Now, let's go to the next slide, because here, remember how I just said there are more than 100 modern awards in Australia? Well, I've just given you two examples. I've given you the example of the Restaurant Industry Award and the Aged Care Award. And with both of them, I've just given you the level 1. Now, of course, many of you might be working at a classification that is higher than level 1. So you need to check your classification. But I've given you level 1 just so that you can compare. And of course, for each pay rate, I've given you the casual rate and the permanent the permanent employee rate. The permanent one, remember, that's less, and the casual one is higher. So can you see that there's a higher rate of pay on Saturdays and Sundays, public holidays? And there's also, I didn't put it into this slide, but there is also a higher rate of pay if you work really early in the mornings or really late at night. So it's very important that you look to see which agreement, which booklet are you covered by? Are you covered by an enterprise agreement? And if not, are you covered by a modern award? Once you know the answer to that, then you have to look at that booklet, that document, to see what your minimum wages are for every different time slot of the week, depending on the days that you work. So how can you find out? Well, here we go. Here's the next slide. The best way to find out is through the Fair Work Ombudsman. They have a database that has every single job in Australia, what the pay should be. So I've given you their phone number there and also their website. And if you use the website, look for the pay and conditions tool. It's an interactive web page where you can get the details of the modern award that might cover you. But personally, I have to say, I would encourage you, even though it's a little bit of a pain because sometimes you have to wait a long time on the phone, but I would encourage you to call the Fair Work info line on that phone number, 13 13 94, because when you speak to them, they first will check if you are covered by an enterprise agreement. And then if you are not covered by an enterprise agreement, they will tell you which modern award applies to your job, okay? So you basically need to be ready to give these details to the Fair Work Ombudsman, and don't be afraid because they keep all your information confidential. They're not going to go back and tell your employer that you contacted them, okay? They need these details to work out what is the right pay for your job. So firstly, you need to tell them who is your employer. You know, is it a business? Is it a company? What's the ABN? If you have the ABN, that's very helpful. Secondly, what is the job title that you are going to be doing? And not only the job title, so for example, waiter or waitress, but actually give them a little bit of a description of your duties. Are you going to be handling cash? Or are you helping with food preparation? You know, because those things make a difference to your classification. Are you supervising other staff or not? Is this your first time doing this kind of job? You know, all that sort of stuff will help them to work out what is your level. And then, of course, you need to tell them, are you permanent or casual? Because that makes a difference to your pay rate. And if you are under 21, you need to tell them your age because that makes a difference as well. Once you give them those details, they put those details into their database and they will tell you exactly what you are covered by. And you can ask them, what about on the weekends? What about on the public holidays? And you can also look up that document yourself. Okay, everyone, I'm sorry that I'm just talking. I've got lots of info for you. I hope you're saving up your questions and I'll have lots of questions in a few minutes. Superannuation is money for when you retire. So it's very important. I know at the moment it all seems like such a long way off for all of you, but the more money you have in your super account now, the better off you'll be later on because it will grow exponentially. Now, we have legislation, and under that legislation, it is compulsory for all employers to make superannuation payments into your super account. But it's your obligation, okay? It's your duty to open a super account, and you cannot ask your employer to put the super money into your normal everyday savings account because they're not allowed to do that. So you do need to have the separate super account and you give them those details when you start a job. That way, all your superannuation money will go to that separate account. At the moment, but this will go up on the 1st of July, at the moment, the extra amount that they have to put into your super account is 11.5% on top of your wages. On the 1st of July, this will go up to 12%. And it doesn't matter if you are a permanent or a casual employee, all employees are entitled to this money, okay? And if you ever move overseas in the future, you can apply to transfer all of that super to any overseas account. But if you haven't opened a super account yet, keep this in mind, because you want to compare which super account is going to have the lowest fees if you transfer money when you move overseas. Okay, everyone, now pay slips. I won't read out, you can read those bullet points that tell you all the information that must be on your payslip. All of this information has to be given to you within one business day, one working day of when you are paid. It doesn't matter if they give it to you in paper form or digitally, electronically, as long as you have access and you can download this payslip with all of this information. So as you can see, all of that information helps you to work out, to understand how your employer has calculated your pay. But otherwise, if you didn't have this breakdown, it would be very difficult to understand, what are they paying you for? They just put $200 into your account, but when do they think that money is for? Which shifts? Were they paying you just a flat rate of pay, or have they given you different rates of pay depending on the different days that you've worked? What's the amount before tax? What's the amount after tax? Have they put any super aside? All that information. When you get a pay slip, it's very clear to you exactly how they have calculated your pay. Now, I mentioned before that when we talk about cash in hand jobs, that means that you are not getting pay slips. And that's against the law. It's against the law for an employer not to give you a pay slip, because what it means is that the employer is treating you as a black market employee. You are operating in the black market. There is no official record that you are an employee. And sometimes I know that students, when they are not getting pay slips, they are very afraid to speak up, because they think, oh, well, am I going to get into trouble with the ATO, the Australian Tax Office? I don't want to get into trouble, so maybe I just don't have any rights. No, I want you to know that you do have rights. The law still protects you. So if you have not been paid properly, for example, you can still do something about it, and you can still also make a complaint that that employer did not give you pay slips, because that's against the law. But the problem is that you won't have much proof, you won't have much evidence that you worked all the hours that you say you worked, or that you were paid however much you say you were paid, because of course you were not getting pay slips. So you need to think about this right from the start. And what I have written in green on this slide is that there is a free app that you can download to your smartphone. It's called Record My Hours. I think it's a very good idea to record that if you are in a cash in hand job, and you enter the details of the address of your employer, and every time you are at that address, it will record those hours, and then make sure you download that data to your computer every week at least. That way, just in case anything happens to your phone, you won't lose all that evidence. But it's not the only app. There are other apps as well. And also, even if you don't use an app, you still could enter, for example, into an Excel spreadsheet. Keep a very detailed list of all the hours that you are working. Don't just put, oh, last week I worked a total of 20 hours, because remember that you have a higher rate of pay depending on the days of the week and the hours. You know, for example, on Sundays and Saturdays and public holidays, or early or late at night. So you need to, if you do keep an Excel spreadsheet, you need to say exactly what day of the week was it, what time did your shift start, what time did it end, did you have any breaks in between? And then if you keep that detailed spreadsheet, then you still can do something about any underpayment, for example, because the law gives you 6 years from when you first didn't get paid properly, or from the first time that you didn't get the pay slip, you have 6 years to go to court. So you have plenty of time to maybe look for another job. And then once you have secured another job with a better employer, if you're still within the 6 years, you can make a complaint against that old employer. Okay. In the middle of this slide, I have said, yes, you may have to pay tax at the end. If you say that employer was paying you $15 an hour, so there's a big underpayment, and then you now bring a case against them because now you've moved on to a different employer, a better employer. So now you want to sue the old employer to get all the money back that you are owed. Yes, there might be some tax that you need to pay to the ATO, but don't be afraid of it because we do have the tax-free threshold, which is 18,200 per year. So what that means, I know a lot of you already know this, but from the 1st of July to the 30th of June, that's our tax year, if you don't earn more than 18,200, then any tax that has been withheld will be paid back to you. So you get all that tax back. And then if you earn above 18,200, it goes up in categories, okay? And it will depend on how much above 18,200 you have earned. That will dictate how much tax you pay. But don't be afraid of that. When employers say to you, sometimes students have a boss that says, oh, it's better for you if there's no tax. No, they're just trying to make you think that it's better for you. But usually it's just because it's better for them because they don't want to have to pay you properly. Okay, so it's not something that you should be asking for to not be on the books. It's something that usually, if they don't give you pay slips, think about why. It's usually because it's a benefit for them. Okay, so now the big question is, what can you do if you are underpaid or you don't get pay slips or you don't get superannuation? Well, the main message that I don't want you to forget is, especially if you are an international student, please make an appointment for free and confidential legal advice through the iSeals project. And in the last slide of this presentation, I have given you the phone number for how, or the email address for how to make an appointment for the iSeals. If you want to, if you feel confident and capable, by all means, go onto our website and have a look. We've got an example letter of demand that you can pretty much copy and then just tweak it, make some little changes to suit your circumstances, and you can send your employer that letter of demand. Of course, you can contact the Fair Work Ombudsman, and you can also go to court on your own. You don't have to have a lawyer. You can do all of that on your own within 6 years. And again, if you do want to go to court, on our website, we have a kit, like a booklet that you can follow that is a step-by-step guide for underpayment claims if you want to go to court. However, for international students, the easiest thing is to start by asking for an appointment for legal advice. Okay, everyone, we're nearly at the end. The last couple of things I wanted to talk to you about were the occupational health and safety issues. So firstly, what is the definition, the legal definition of workplace bullying, so that you can recognize it if it's happening around you in your workplace? And also, what is the legal definition of sexual harassment if it's happening in your workplace? You will see that both of these horrible things have three parts to the definition, but those three parts, those three components are very different. So let's start with workplace bullying. Workplace bullying is repeated. That's very important. Must be repeated. And it must be unreasonable behaviour towards you as a worker or towards a worker. And that repeated and unreasonable behaviour creates a risk to your health and safety. And if you have all three of those elements, it equals workplace bullying. Sexual harassment instead has a different definition, but still three parts. It is unwelcome conduct. So that's purely subjective. Unwelcome to me. It's conduct of a sexual nature. So that's very, very broad. It can be physical, but it can also be verbal. It can be messages that I send. It can be jokes that I make. It could be visual things that are up on the wall or on the computer or being sent by message. It's very, very broad what is conduct of a sexual nature. And the first bit was the subjective test, unwelcome to me. The third part of the test is the objective test. It's conduct that a reasonable person would have known was likely to offend or humiliate or intimidate another person. So if the behaviour fits all three parts of that definition, it equals sexual harassment. Now, what can you do and who can you talk to if there is any bullying or sexual harassment in your workplace? Well, the number one thing is, of course, please tell someone that you trust, whether it's a family member, a friend, a teacher, someone at GSA. Of course, in yellow, I have highlighted, if you are an international student, make an appointment for legal advice straight away through the ISEALs. Even if you are not an international student, I'm going to give you in a second the details for how to contact JobWatch. Please contact JobWatch because we are here for you. We never want anybody to suffer in silence, okay? We are here for you. JobWatch, if you call us, it is, again, free and confidential help over the phone. Depending on the behaviour, and this, of course, depends on how comfortable you are in that situation because there's no two situations that are the same, but it is perfectly fine for you to say to the person who's behaving like this to stop. And sometimes that's enough for it to stop, but I know that it depends on the circumstances. Other times, if you don't feel comfortable to say that or you have done it and it hasn't worked, then the next step would be to make a formal complaint within your workplace. If you are suffering any kind of symptoms, physical symptoms or psychological symptoms, you need to go and speak to your doctor. And of course, if it's bad enough, you might need to go to the police. So all of those options exist, but the number one message here is please speak up. Speak up, tell someone that you trust because suffering in silence never makes the behaviour go away. So here we are, everyone. We've come to the last slide. On the left-hand side, I have given you the details for how you can ask for an ISEALS appointment. If you are an international student and you need legal advice about work rights or accommodation, you can phone or email Study Melbourne and say, I need legal advice. And then remember what I said to you, that if it's a work matter, it's very likely that it will be JobWatch that will give you the legal advice. But there are also the other two community legal centres available as well. So we all share that project. If you are not an international student, and of course, even if you are an international student, everybody is welcome to contact JobWatch. And I've given you here the JobWatch website. We have lots of information sheets on our website. So I think that's a really good first place to have a look to see if you find the information that you are looking for. But also I've given you the phone number, and I imagine that all of you are within Melbourne Metro. So that's the 96621933 phone number. And you can call us Monday to Friday from 9 until 5 p.m. So we operate sort of, full-time hours during the week, Monday to Friday. And we do have one late night on a Wednesday. So on Wednesdays, the phone line is available from 9 in the morning until 8:30 at night. Okay, everyone, we've got 10 minutes or so for some questions, if anyone would like to ask some questions. So over to you. It doesn't matter whether you want to just take yourself off mute or if you want to use the chat.
Yeah, hi. I just want to first say thank you so much, Gabrielle. That's very insightful. And yeah, I just want to say GSA is very grateful. We have 5 questions, which is in the chat. Do you mind me reading them out?
Fantastic. Go for it, Alexander. Thank you so much.
So the first one is, what are the employer's obligations to redeploy staff after mass redundancy? Is it
Mhm.
providing a list of all the jobs available enough? The company advised that after my final date, if they advertise a similar job, I would need to reapply with the rest of the job market. Is this lawful?
Okay. Wow. Fantastic question. Good on you for the person who's asked this. Now, the way I would answer this question, the first thing I would say is if you have joined a union, because this person who has asked this question sounds pretty knowledgeable. So if you have joined a union, and for anyone who doesn't know what a union is, by the way, a union is an organization that you have the right to join if you want. No one can force you to join or not to join. It's totally up to you. You've got that free choice. And if you do join a union, you pay a membership fee to them, and then they help you with your work, any work situation in that workplace. So if you have joined a union, they would be the first people that you should let know about this mass redundancy, because especially when there's a mass redundancy, it's a really good idea for at least a few of you to be union members. That way, the union can make sure that they are looking after all of you and make sure that the employer is doing the right thing. But if you are not union members, then the steps are that the employer, when they have decided that a particular position or a lot of positions have to go, and that's obviously the redundancy situation, the next step before they go ahead and dismiss people, they have to consider, is there any reasonable redeployment for these people? So are there any other opportunities for them within our not only the existing business, but any related businesses as well? Okay, so it's broader than just within that specific business where you already work. Now, if you've got concerns, because sometimes what happens is, let's say I'm the employee and my boss says to me, sorry, Gabrielle, your job as a lawyer, we've had 10 lawyers up until today, but now we've made a decision that after today we will only need 8 lawyers. So actually 2 lawyer positions are going to disappear. And we are going to create, or we already do have potentially, these other positions that a lawyer could do, for example, a legal research officer or something like that, right? And so I might say, well, I think you should consider me for that position, the legal research officer. And then they come back and say, no, sorry, that's not available to you anymore. And so then if you're in that situation, the person that has asked this question, the best thing to do is to come and get some legal advice through the ISILs if you're on a student visa, or otherwise look up the JobWatch fact sheet on our website all about redundancy, and we go through a step-by-step explanation of what happens in redundancy situations.
Brilliant. Do you want me to read out the second question?
Yes, please.
So the second one is, how do we determine fair salary benchmarks for different roles? Are there legal guidelines or industry standards that can help ensure employees receive appropriate compensation?
Okay, well, these are great questions. I love how sophisticated the questions are, but I'm not sure whether the person who's asking that question, are you, I mean, maybe if that person wants to unmute themselves and just clarify, are you meaning beyond what's the minimum wage in the award or the enterprise agreement? Are you thinking that, do you know that you're covered by a modern award or an enterprise agreement, and then on top of it, you want to say that all the employees in your workplace should be getting a higher rate of pay? Is that what you're getting at?
Yeah, if that person wants to speak, or they can do another anonymous question if they want to clarify, if they want to remain anonymous. Uh,
Yeah, because at
they
the end
want
of
to
the
know
day, the important thing is that what the obligation on the employer is to pay at least the minimum in the enterprise agreement or the modern award.
that they clarified that they wanted to know it in general.
Yeah, well, but it doesn't work like that. That's what I'm saying.
Yeah.
The obligation of employers is to comply with the minimum payments that they owe you under an enterprise agreement, a modern award, which is for the whole industry or occupation, or if you have got a specified amount in your individual employment contract that's written down. They've got to pay you at least those amounts. If you all want to get together, all the employers, and you want to say, you're not covered by an enterprise agreement, for example, and you want to negotiate an enterprise agreement with your employer, again, then I come back to the benefits of joining a union. You should really think about that. Um, or you can also look up on the Fair Work Commission, not the Fair Work Ombudsman, Fair Work Commission's website. They have information about how to negotiate an enterprise agreement. An enterprise agreement, remember, it's just a collective agreement. So when a lot of you come together and you want to negotiate an enterprise agreement with your employer, even without a union, there's a step-by-step guide on the Fair Work Commission's website.
Thank you for that clarification. And then our third question is, can a supervisor tell you right out to your face to find another place, and that you don't need to come back after your long-term leave?
Ooh, okay. Um, if that has happened to you within the last 21 days, again, fantastic question. Thank you for the question. Because we didn't even get to talk about if there is a termination of employment. So well done for raising this. If there is you know how I was saying to everyone, you have 6 years to go to court if you haven't been paid properly, or if you haven't got your pay slips, or if you haven't been given your superannuation. 6 years is a really good long time frame, right? But unfortunately, if you have been dismissed, you only have 21 days, which is, we hate it at JobWatch. We think that that is a ridiculously short time frame, but unfortunately, that's what the law is at the moment. 21 days. So that's only 3 weeks. It includes weekends and public holidays. From the date of the dismissal, you only have 21 days to make a complaint about that dismissal to the Fair Work Commission. So the person who has asked this question, if this has happened to you and it's within the last 21 days, I definitely urge you, if you're a student, quickly contact State Melbourne and ask for an urgent legal advice appointment about a dismissal. If there is no dismissal yet, but the employer has said this to you, but it sort of hasn't happened yet, then of course that's good. You've got more time. And then I would definitely urge you to look up the JobWatch website. We've got lots of information under dismissal. So unfair dismissal information, read that and then give us a call at JobWatch if you need further clarification.
Thanks for that answer. For the previous question, that person says that they also understand. So just so that you know. And then the fourth question is, will the tax deduct from the hours payment rate, or is the employer the one who needs to pay the tax?
If you're an employee, it's your employer who handles all the tax. They withhold the tax, send it over to the ATO, the Australian Tax Office, and at the end of the financial year, you have to put in a tax return. And if you haven't made more than 18,200 for you will get all the tax back. Okay, that's how it works if you're an employee. But if you are genuinely running your own business, then it's up to you to handle all the tax.
Great. And final question is, will I get pay when I am on the probation period of a part-time job and there is no written document between the employer and I?
Yes, yes. Again, when there is nothing in writing, it makes it really tricky to prove that you were working all the hours that you say you were working. Okay, so that's the issue, the lack of proof. However, your question is, do I still have a right to get paid? Yes, absolutely you do. Remember I said if you are an employee, you have a right to get paid at least the minimum pay for every hour that you work. So your big challenge now is to make sure that you write down a really good comprehensive list. Don't make anything up, but go through your records, write down every shift that you worked. What time did you start? What time did you finish? And once you have those details, if you're a student, please contact Study Melbourne for a legal advice session. And otherwise, follow, if you're not on a student visa, follow the information on the JobWatch website. Um, have a look at our example letter of demand, okay? Because you definitely are entitled to be paid for every hour that you have worked. Doesn't matter if it was a trial, if it was called a probation period, it doesn't matter. The employer can't say to you, oh, I'm not paying you for that trial period or that probation period, or you were very slow, so I'm not going to pay you the full amount, or I'm just going to pay you less. No, that's not okay. If you are an employee, you must be paid at least the minimum for every hour that you have worked. But you need to think about how are you going to prove that you worked all those hours.
Brilliant. That's all the questions there. We had a few which they submitted previously. Do you have time? I think there are two ones which I think might be important. It's 1 p.m. already.
Totally up to you, Alexander, whether you want to, how you
I
want to
think
handle.
I think just one on the two of these that were submitted kind of relate together, but it's about workplace bullying,
Yes.
and the types of workplace bullying that perhaps aren't the usual examples, and how to remedy that situation. But also about another thing in a question was they didn't want to stir things up, or raise a matter to something, and just I think suppose giving help and navigating that situation too.
Yeah. Okay. So look, I think then the best way to answer the question is really to urge you, to encourage you to make an appointment for legal advice. Okay. So that way, that will be the best way, whether it's me, there's a very good chance that it will be me personally, but even if it's one of the lawyers from the other community legal centres, everyone is here to help you. Okay, if you have a student visa, please contact Study Melbourne, say that you want an appointment for legal advice and discuss that with the lawyer in that session, because then we will give you all the information specific to your situation. If you're not on a student visa and you're asking that question, please jump onto the JobWatch website, look up our fact sheet about bullying and harassment in the workplace, and then give us a call if you need anything just clarified for you or to talk about next steps. But it's definitely, it's not okay to be putting up with bullying and harassment. It's just that sometimes people need to understand, does it sound like workplace bullying or not? So that's, of course, what we're here to help with, and we can talk to you about the next steps.
Brilliant. That's all the questions then. Thank you so much, Gabrielle.
Okay, you're so welcome, and thank you everyone for being here. And good luck with everything.
Thanks. That closes the webinar. And we'll give you the resources to all the students to help reach out to you, and those other resources. I was going to talk more about the GSA, but it's like no expectation to stay.
Okay, I'll jump off. Thank you so much, Alexander and Jamie and
Thank
Thanks,
you.
everybody.
Gabriel.
Bye.
Bye.